Joining me now from Washington, D.C. is Bilal Wahab. He is a fellow at the Washington Institute of Near East Policy. From London, we have Iraqi affairs analyst and legal consultant Salah Hashimi. And also from Washington is Douglas Ollivant, senior vice president of the strategic consulting firm Mantid International. Thanks all so much for joining us on the Newsmakers. Douglas, let me begin with you. There are really so many issues at play here, and not least what is actually legal under the Iraqi constitution. And you believe it's precisely the constitution that's both the cause of and arguably the solution to this dispute.
Sure. I think there are, let's stipulate the Iraqi constitution is really poorly defined. There are many terms in it that are not defined, and there are clauses that contradict. I think there are three that are really relevant to this discussion. There's a clause in the Peace on Regions that says that the regions and the federal government must jointly administer existing fields. Existing fields are not defined, and what is a field that is not currently existing is also not defined. But at least by implication, there are maybe fields that could be administered by the regions alone. So this is the clause that most favors the KRG's interpretation. But then there are two other clauses in the Constitution. There's one that quite explicitly says that all of Iraq's natural resources, particularly the oil, belong to all Iraqis, which implies it belongs not to just the people who live on top of it, but all 18 provinces of Iraq. And then there's another clause that states that the federal government has responsibility for sovereign economic policy, and presumably international pipelines and things of this nature would fall under that clause. So I think in the regions, there's some language that favors the KRG interpretation, but elsewhere there are two clauses that favor federal Baghdad's interpretation, and it's really a constitutional muddle.
Okay, Bilal, let me ask you, does this come down to what is essentially a somewhat vaguely written series of constitutional articles that have allowed for this controversy over the KRG and its control of the oil fields to develop?
I agree with what Doug said, but let me add two other principles that the Constitution also enshrines. And one of them is oil federalism, that the central government doesn't have exclusive authority over the management and production of oil, and gives quite some leeway to not only the Kurdistan region, but any other province that may engage in exploration and production. That's one. The other principle is the principle of revenue sharing. The Constitution has two words that need to be explained. One of them is the word with, so the federal government with the provinces and the regional government, and then there is another word which is together. Now, obviously, this is very vague, and Iraq needs legislation to delineate the rights and responsibilities of the federal government vis-a-vis the regions, and such a law does not exist, and therefore both the Iraqi government and the KRG have taken matters into their own hands, into their own interpretations that favor them based on balance of power rather than rule of law.
Okay, Salah, let me ask you. Some are saying that the Kurdish Regional Government is arguably, the best-run administration in Iraq. Some say it's safer and less corrupt and therefore more prosperous. And if it loses that autonomy via losing control over its resources, it will actually move the region backwards. Do you think that's true?
Well, I think, let me just comment first on what my two colleagues have just said. I think the absence of a clearly defined law governing the oil and gas in Iraq has created a major legal vacuum for both the Iraqi federal government and the Kurdish Regional Government. Now, it is absolutely correct that the Kurdish Regional Government is the most stable part of Iraq. However, I think Iraq is coming into fruition. I think the other parts of Iraq are becoming far more stable than they used to be. You're right in saying that the Constitution was basically the flag point as to the entire conflict and the underlying causes of it. I think it's fair to say that the Constitution was drafted under circumstances that were not clearly favorable to the federal government of Iraq. It was drafted in circumstances whereby the country was unstable and clearly under occupation. And therefore, anything that would have been construed as favorable might not be after a number of years. Now, to say that to dispute any of the oil contracts made with international oil companies with the Kurdistan Regional Government will set the entire region of Iraq backwards, I think is a misstatement. Because what we need is a proper regulation, a proper administration of these contracts between federal Iraq and these oil companies. And let us not forget that the dispute between the federal government and the regional government not only lies with the signature of these contracts, it's actually the types of contracts. The types of contracts that the Iraqi government are offering are quite significantly different from those that the Kurdish Regional Government is offering. And that is creating an imbalance within the region itself. I think that also needs to be considered as part of the entire issue.
Bilal, let me just ask you then point blank, what would be a fair decision, in your opinion, for the court to make?
The court is actually in a tough spot because it will be interpreting the Constitution, but the Constitution itself is vague, sometimes described as aspirational. The precursor to a court ruling I would propose would be the challenge for the next parliament to actually pass the National Hydrocarbons Law. There was a draft in 2007 that both KRG and Baghdad agreed on, except for some minor glitches that ended up undermining the passage of that law. And then there were new versions in 2011. So right now, where Kurdistan's independence, at least economic independence, is not moving forward, and there is reintegration, economic and energy reintegration between KRG and Baghdad, it's time for the upcoming Iraqi parliament, we have elections on May 12, to actually pass that national hydrocarbons law. This ruling that's in front of the Supreme Court right now, the Constitutional Court, might actually create facts on the ground in favor of Baghdad and therefore undermine the passage of the national oil law, because the KRG is in an economic, political, and security weak position, and a ruling that is deemed to favor Baghdad, because indeed in the realm of oil exports and commercialization of Iraq's hydrocarbon resources, the Constitution does favor Baghdad. So, in fact, the KRG is slated to lose, but that will undermine the passage of the national oil law, which is going to set Iraq and KRG energy relations on a rule of law basis, based on institutions rather than political bickering.
But Bilal, while you say the KRG is in a politically weak position right now, I mean, proponents of the Kurdistan Regional Government, or the Kurdish Regional Government, say that is because they are being unfairly punished by the government in Baghdad. And Douglas, let me point this to you. They're saying they're being unfairly punished because they wanted the independence that they were supposed to get. Though it wasn't guaranteed through this vaguely written constitution, this was supposed to be an option for them. Is there some legitimacy to that complaint that they are being targeted by Baghdad because they have only gone forward with what they were supposed to have when Iraq was liberated, if we can use that word, from Saddam Hussein?
I don't think that's a fair interpretation. I think that certainly what has happened in the wake of the reoccupation of Kirkuk, the bringing of Kirkuk and the other disputed territories under federal control, has been a redefinition of what the federal arrangements between Baghdad and the KRG are. As we've all noted here, I don't think there's any disagreement between any of us. The Constitution is extremely vague. And therefore, while the old arrangements in which the KRG had much more autonomy were clearly constitutional, the new arrangements are equally constitutional. So I think that's where we are with Baghdad redefining the terms in the wake of its recovery from ISIS. Now, just to clarify an earlier point on the relative transparency of Baghdad and Erbil, I think actually the opposite of what you said is the case. The oil situation in the north is remarkably obscured. We really have no idea how much oil the KRG produces, what they sell it for, what are their expenses. That's all very, very vague, very hazy. Whereas, thanks to the occupation, one of the virtues of Iraq's oil sector having been administered by the Americans is there's remarkable transparency. We know how much oil is produced, we know what it's sold for, we can track it as it leaves Iraq. Now, there are obviously lots of other problems in Baghdad, but oil transparency is a virtue in the South that really needs to be applied in the North.
Okay. Salah, let me ask you, there is, of course, the argument that if the KRG is allowed to sell its oil independently, it will only give further impetus to the independence movement in the region. What do you make of that argument?
Well, I think I would certainly agree with that, because certainly before the Iraqi army moved into Kirkuk and pushed the Kurdish security forces, or the Peshmerga, out of it at that time, Kirkuk was a great, huge, big incentive for the Kurdish Regional Government to declare independence because of its oil wealth. I think to say that Iraq's oil, as my colleague in America was saying, being correctly administrated and very transparent, I think that is somewhat of an understatement, because we do know of plenty of undeclared profit being made out of Iraq, not in the accounts of the government, but otherwise there are certain factions who have capitalized on the oil production that has not been declared by government books. So that certainly needs to be known. Now, in other terms, I think the conflict between the constitution, the Iraqi constitution, and that of the Kurdish administrative government will be dealt with in this court. But I think what's interesting is the court's declaration that the Prime Minister of Iraq himself, the Finance Minister of Iraq himself, and the Kurdish Prime Minister himself as being named as claimants or defendants in this case. Now, the reason why the court has declared that is because it sought that the case, first of all, had a political, constitutional, and financial perspective. That is somewhat unheard of in Iraq's modern legal history. But I think I would await to see the judgment. But let us not forget, I think the court will be mindful of the contracts that have been signed and the companies that have accepted these contracts. Let us not forget that before signing these contracts, these oil companies carry out a very thorough due diligence procedure, whereby they would be very cautious about entering into any financial or contractual obligations before they are almost certain that these obligations and any commitments will be met in the future.
Okay.
So let's just wait and see.
Salah Hashimi, I will have to give you the final word because unfortunately we're out of time for this segment of the Newsmakers. I'd like to thank all three of my guests so much for joining us.